morning, the US Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay his trial for interfering in the 2020 election. The former president described the decision as a big win. Our North America editor Sarah Smith reports.
The powerful Supreme Court has the final say on what presidents can and cannot do. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties, but they do not have immunity for non-official acts. So what does this mean for the criminal cases against Donald Trump?
Fight for Trump! Fight for Trump!
When he spoke to supporters on January the 6th, was he officially acting as the president or as the losing candidate?
We fight like hell, and if you don't fight like hell, you're not going to have a country anymore.
Hi everyone, Adam is here. Here is what almost everyone gets wrong about the Supreme Court immunity ruling that just landed in the middle of every single criminal proceeding involving Donald Trump. The headlines screamed that Trump won. The political commentary declared he had been handed a shield that would protect him from everything.
This is an absolute win for Donald Trump, not just the substance of the opinion, but also the court had the option here to make the decision effective immediately or go through a traditional waiting period of 25 days. There's no expedited period. This effectively grants Donald Trump blanket immunity because it makes it seems to me now, impossible for a trial to go forward, either in the classified documents case, because this is also at stake there, and the January 6th case. And I think when you look at the dissenting opinion, Devin read part of it. This line stands out to me. Says the decision, quote, makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law.
And if you only read the first few pages of the decision, you might actually believe that was true. But here is the thing about Supreme Court rulings. They are not press releases. They are not designed to generate favorable headlines for anyone. They are legal documents with multiple parts, multiple sections, multiple paragraphs. And buried inside those paragraphs are words that matter just as much as the parts everyone is talking about. And in this ruling, tucked inside the constitutional architecture the court built, is a specific line that changes everything about how Trump's legal exposure looks going forward. A line that his defense team absolutely did not want to see. A line that prosecutors in multiple jurisdictions are now circling with highlighters. A line that says in plain English, with zero ambiguity and zero room for interpretation, that the president has no immunity for unofficial immunity. Zero, none. Not reduced immunity. Not presumptive immunity that can be rebutted. Not immunity that applies in some circumstances but not others. No immunity, stated as a flat constitutional rule by the highest court in the land, in the ruling that will govern every single immunity argument Trump's lawyers try to make from this moment forward. Let that sink in for a second. The court gave Trump real protections, absolute immunity for a narrow core of constitutional powers, presumptive immunity for other official acts, an evidentiary wall that prevents prosecutors from using immune official acts as evidence against him even in cases focused on unofficial conduct. Those are real. Those matter. Those will shape how certain cases proceed. But the court also drew a line. And on one side of that line, the president is protected. On the other side of that line, the president is just another defendant with no special constitutional force field around him whatsoever. Now here is where it gets interesting. Everything that actually threatens Trump's freedom, every criminal proceeding that keeps his legal team up at night, every accountability front that could actually result in consequences that matter, lives on the unofficial side of that line. Pressuring state officials to change certified election results through personal phone calls? Unofficial. Running a fake elector scheme through campaign operatives and personal lawyers instead of through official government channels? Unofficial. Arranging hush money payments through a personal attorney and then falsifying business records to cover it up? Unofficial. Running a business fraud operation through a family real estate company? Unofficial. The core constitutional powers nobody was prosecuting him for, those are protected. The personal conduct that every single criminal investigation is actually built around, those are wide open with no immunity whatsoever. And just to make sure everyone understood exactly what no immunity for unofficial acts means in practice, a judge in New York named Juan Merchan decided to demonstrate it in real time. Right there in the Manhattan criminal courtroom where Trump sits at the defense table as a criminal defendant, Merchan has been building a record. 10 times he has found Trump in contempt for violating a gag order. 10 separate violations, 10 separate findings, each one carrying the maximum fine available under the law. And when the fines did not work, when Trump kept attacking jurors and witnesses despite being told to stop, Merchan did something extraordinary. He put it in writing. He formally found that the financial sanctions have not deterred the conduct. He put Trump on official notice that future violations would be punishable by incarceration. And then he looked at the former president of the United States, sitting right there in his courtroom, and told him directly that jailing him might be the last thing he wished to do, but that he could not allow attacks on the rule of law to continue. A sitting judge telling a former president to his face that jail is on the table if he keeps violating court orders, in the specific courtroom where that former president is sitting as a criminal defendant, with no special constitutional protection around his personal conduct because the Supreme Court just ruled that for personal conduct there is no immunity at all. Are you kidding me? This is what the no immunity zone looks like when it meets a judge who has had enough. This is what the Supreme Court's flat rule means when it collides with a defendant who thinks the rules do not apply to him. This is the real-world demonstration of what happens when a court decides that, former president or not, the law applies the same way it applies to everyone else. Now let us walk through the full architecture of what just happened, because this ruling has multiple layers and each one matters for understanding exactly where Trump's legal exposure stands. The Supreme Court built a three-tier structure. Absolute immunity for core constitutional powers. That covers things like the pardon power, the veto power, core commander-in-chief functions, the stuff that is undeniably presidential. Prosecutors were not trying to charge him for those things anyway. Presumptive immunity for other official acts. That covers the broader range of conduct that falls within the president's official duties. Presumptive means it can potentially become immune unless prosecutors can show that applying criminal liability would not improperly chill legitimate official authority. This is where things get complicated. This is why the January 6th case got sent back to the trial court, because someone has to sort through all the conduct and figure out which pieces were official and which were not. And then there is Tier 3, no immunity for unofficial acts, flat, absolute. No exceptions. The president gets nothing for personal conduct. And here is the key. The conduct that actually threatens Trump legally, the conduct that prosecutors in multiple jurisdictions have spent years building cases around, lands almost entirely in Tier 3. Think about the fake elector scheme. That was not run through the White House. That was run through campaign operatives and personal lawyers using campaign infrastructure. That is not official action. That is political operation. Think about the pressure on state officials. Those were personal phone calls, not official government communications. Those were demands aimed at state-level electoral processes that are explicitly outside the president's constitutional responsibilities. That is unofficial conduct. Think about the hush money payments, arranged by a personal attorney, processed through a family business, designed to serve a campaign interest, nothing official about any of it. The Supreme Court did not just accidentally leave these cases exposed. They drew a line and put all of this conduct on the prosecutable side of it. Now add the evidentiary wall. This is the procedural protection the court built that bars prosecutors from using immune official acts as evidence to prove unofficial criminal conduct. On paper, that sounds like a protection for Trump. And in some ways it is. It means prosecutors in mixed conduct cases have to build their cases using only the unofficial evidence. They cannot lean on official act context to connect dots. But here is what that actually means in practice. It means the prosecution of unofficial conduct has to live or die on the unofficial side of the line. It means the fake elector scheme, the personal pressure campaign, the hush money arrangement, all of that has to stand on its own without help from official act evidence. And that is exactly where prosecutors want to be, because that conduct is damaging enough on its own without needing any official context to make it criminal. The January 6th case got sent back to the trial court for line drawing. That is true. That will take time. That will require detailed factual analysis of each element of the alleged scheme. But the Supreme Court sent it back with explicit instructions. The president has no immunity for unofficial acts. Go figure out which parts are unofficial and prosecute those. That is not a get-out-of-jail-free card. That is a roadmap for prosecutors to follow. Now bring it back to Judge Merchan, because this is where the abstract constitutional ruling meets actual consequences in a live courtroom. 10 contempt findings. That is not a small number. That is not an accident. That is a pattern. Each one for attacking the specific people the gag order was designed to protect. Jurors, witnesses, the people essential to the integrity of the proceeding, the people whose safety and freedom from intimidation make fair trials possible. And when the fines did not work, Merchan did not just shrug. He did not just issue another warning and hope this time it stuck. He formally found in writing that the financial sanctions have not deterred the conduct. That is a specific legal finding. That is a predicate. That is the exhausted deterrence record that justifies moving to the next level of consequences. Then he issued the warning. The last thing I wish to do, but I cannot allow. That language matters. A judge who says they do not want to jail a former president is a judge acknowledging the gravity of the step. But a judge who says they cannot allow the conduct to continue is a judge making a public commitment, a binding institutional commitment. A commitment that, if violated, leaves the court with no credible choice but to follow through. And the follow-through is incarceration. Jail. A cell. For a former president of the United States. In a proceeding where the Supreme Court has already ruled he has no immunity for personal conduct. This is not theoretical. This is not political commentary. This is a documented record in a live criminal case. 10 violations. Exhausted financial sanctions, a formal finding of continued defiance, a public judicial warning that jail is next, and a Supreme Court ruling that says for this kind of personal conduct, there is no constitutional protection whatsoever. The immunity shield is real for official acts. The no immunity zone is equally real for personal crimes. And in that zone, Trump is just another defendant, subject to the same contempt findings, subject to the same gag orders, subject to the same incarceration exposure as anyone else who willfully defies a court's lawful orders. So here is where we land. The Supreme Court gave Trump something: absolute immunity for core powers, presumptive immunity for official acts, an evidentiary wall that complicates mixed conduct cases. Those are real protections with real legal consequences. But the court also withheld something. They withheld immunity for unofficial acts. They drew a line and put all personal conduct on the prosecutable side of it. They wrote in plain language that the president has no protection there. None. Zero. And everything that actually threatens Trump's freedom lives on that side of the line. The fake elector scheme, the pressure on state officials, the hush money payments, the business fraud, all of it. Unofficial, personal, prosecutable. Judge Merchan is already showing what that looks like in practice. 10 contempt findings, a formal exhausted deterrence record, a public incarceration warning. A judge who has made it clear that former president or not, the rule of law applies. The January 6th trial court is now doing the line-drawing work the Supreme Court required. And every element of the alleged election interference scheme that lands on the unofficial side of that line is fully prosecutable under the constitutional framework the immunity ruling established. Every single one. The immunity shield is real for official acts. The no immunity zone is equally real for personal crimes. The Supreme Court drew that line in plain language, and Judge Merchan is already demonstrating in a live proceeding exactly what no immunity for personal conduct means when the defendant at the table keeps violating court orders. It means jail is on the table. It means former president or not is the equalizing principle the court is applying. And it means the specific constitutional protection that would have been most useful for the most serious accountability exposure is the specific protection the Supreme Court most explicitly and permanently withheld. Stay tuned, Because every future gag order violation in the hush money proceeding is going to be evaluated against that have not deterred finding and that last thing I wish to do, but I cannot allow commitment. And every element of the election interference case that lands on the unofficial side of the line is going to be prosecuted under a constitutional framework that provides zero immunity for the conduct that actually threatens Trump's freedom. The court built a shield, but they built it in the places where no one was shooting, where the bullets are actually flying, where the real legal exposure lives, where the consequences that matter are concentrated. The court left him completely exposed. And judges like Merchan are already proving they will treat him exactly the way the law treats anyone else who does what the record shows he did. That is the accountability picture. That is what the no immunity zone looks like. And that is what is coming next.